Today's video covers a case study, $962,500 settlement for an 18-wheeler accident injury requiring surgery. Brought to you by the Mullen Mullen Law Firm of Dallas, Texas. Our client was a passenger in an automobile traveling west on US 287. A negligent semi-truck driver made an unsafe lane change and clipped our client's car. She was taken to the hospital via ambulance, due in part to her medical history, which included a prior major spine surgery. Notably, having a prior condition does not mean you do not qualify to make an insurance claim. In fact, the opposite is true. Texas recognizes the Eggshell Plaintiff doctrine. For example, a healthy 25-year-old male involved in a minor wreck may need only a few weeks of physical therapy to fully recover. On the other hand, if your grandmother with late-stage osteoporosis was involved in the exact same collision, she would likely break multiple bones due to her pre-existing condition. The medical costs for each person are vastly different, but that doesn't absolve the negligent party from full responsibility in either case. Upon examination, our client's new imaging studies were nearly identical to her prior spine imaging, but she was experiencing increased pain and discomfort. Given our client's background, we stressed the importance of making sure any new or increased symptoms were properly documented. The client eventually underwent laminectomies at C5-6 for decompression of the thecal sac and exiting nerve roots. Translation: she had tremendously invasive back surgery. Her neurosurgeon noted bilateral foraminal stenosis made symptomatic following the accident. Translation: she was in terrible pain after the accident. Unsurprisingly, the trucking company's insurance carrier battled our claim by noting that property damage was only moderate and that the force of the impact could not have resulted in the need for surgery. We passionately argued that someone with a pre-existing condition is more susceptible to injury when involved in a collision, and she shouldn't become a victim twice by being denied her claim. We drew the adjuster's attention to the documented new and increased symptomology which necessitated additional major spine surgery. She obtained a settlement offer without the necessity of costly and time-consuming litigation, and she saved over $70,000 with our reduced contingency fee rate. Here's how the funds were distributed. Case expenses, $251. Attorney fees, $250,154. Medical fees, $333,767. Net payment to client, $378,328. Bottom line, insurance companies will try to undermine and reduce the size of your claim any way they can. Retain an experienced injury attorney who is willing and able to fight to make you whole, regardless of whether you're a Gumby or a Humpty Dumpty. If you've been injured in an accident, call the Mullen Mullen Law Firm right away for a free case evaluation.